Good morning. We are going to go ahead and get started. Welcome to our Women's Wednesday Entrepreneur Series. I'm Brandy Stitt, the Program Director for the Women's Business Center in Kansas City. Thank you all for joining us. We have been hosting these sessions every Wednesday at 10 o'clock on a variety of topics that are relevant to our small business community that has been impacted by COVID, which is pretty much all of us. We're covering topics from financial resources, social media, marketing, and today we're focused on legal topics, specifically commercial leases. We are recording this session. We've been recording all of our webinars and posting those on our YouTube channel, which we will do with today's session as well. So it will be available for you to revisit this webinar or to share with other small business owners that you think could benefit from a particular topic. So we will share that YouTube recording once we have that available. It takes us about a week to get it edited and posted. So look for that soon. At this time, I would like to go ahead and introduce Judy Sharp. She is with the UMKC Legal Services Clinic, and she's going to be joining us as our presenter today. And Judy, I'm going to go ahead and hand it over to you.
Thank you, Brandy. Hello, everybody. My name is Judy Sharp. Like she said, I will confirm that. And I have been a lawyer for 43 years. I'm retired now, but I was formerly the director of the UMKC Entrepreneurial Legal Services Clinic. That is a law school program wherein our law students enroll for credit, and under my supervision and now under my successor's supervision, excuse me, meet with people who want to start a business and help them navigate the legal landscape of that, including getting the choice of entity that they need for their company. I'm very sorry. And then helping them to create that by drafting the documents for it. My legal ethics require that I tell you that I'm making a public presentation today on the law and that I'm happy to answer your questions, but please take note that there is no attorney-client relationship that will attach to my answering your question, and it will be a publicly aired question and answer. So I am going to share a PowerPoint that I have here, where, as Brandy said, we are talking about commercial leases and what kind of provisions they commonly have. So, Brandy, is this showing properly, or do I need to switch?
It looks like it, yeah, it's showing your first two slides. So your first slide and then the next slide, which is fine if that's the way that you want it to show.
Well, I want to give you just the slide I'm talking about on. So if you'll bear with me here just a minute, I'll try to get this changed. Here we go. Did that work?
Yes, that's
okay.
Perfect.
Okay, so backing up here, we're talking about common provisions of commercial leases. And what are the common ways that a business can breach the terms of a commercial lease? Well, as you can imagine, of course, there's the classic, I didn't pay the rent and can't pay the rent, but there may be other ways hidden in your lease that you don't realize. And so landlords are called lords for a reason. That's because historically in the evolution of our laws, real estate was the original form of wealth. If you think of feudal England, for instance, all of the money that anybody had when they were rich was based on the ownership of land that, all came from the king, basically. And so I don't know how many of you have ever read your residential lease, But if you, most of the time, these legal documents come to us and we understand that we're not going to be able to rent the apartment or the retail space without signing the lease. And we make the mistake of either not reading it or even I would recommend having a lawyer look at it for you. Of course, most of us don't feel like we have the means to do that. But if you ever read your your residential lease, you might have been appalled at how few rights you have as a tenant. Well, as a commercial tenant, you have even fewer rights. So I like to tell people that generally the commercial landlord is going to win any dispute that you may have. But let me make sure that you at least understand what you get yourself into when you sign one of these commercial leases. So the commercial tenant has actually more responsibility than a residential tenant. So in your apartments, of course, you have a duty to keep the premises in good shape and to call your landlord, for instance, when the plumbing breaks so that he can have it repaired, usually at your landlord's expense, and prevent any further damage to the building. And you have to pay your rent on time, and you have to not bother the other tenants, etc. But what you need to understand about commercial leases is that they are taking on even less responsibility, the landlords are, than they do in a residential situation. So the commercial landlord is going to impose a lot more responsibilities on their tenants, and they are going to make as minimal a capital investment in the properties as they possibly can. So many of these commercial places will be highly mortgaged. The landlord has made a minimal initial capital investment. He's depending on the rents to be paid by the tenants so that they can pay the mortgage payments. And they're going to pass on as many of the costs to the tenants as they possibly can. So what you're going to see most of the time in a commercial lease setting is you're going to see a net lease, which means that the landlord is going to collect all the rents and pay its own mortgage, but it's going to invest very little in the property. And they're going to charge back many of the expenses that they would have to the tenants that are in that property. So how many ways as a tenant can you default on a commercial way? Well, a commercial lease. Well, let me try to enumerate those for you. The classic one, of course, is non-payment of rent. So in the pandemic, I can imagine that there were a lot of tenants, especially in retail spaces, where they had to close. They didn't have any revenue coming in. Maybe they were trying to keep some kind of minimal salary going for their workers. But I'm sure that it's been very rough. I know we all can name examples of businesses that have gone out of business rather than try to tough it out through the pandemic and come back out on the other side with a business that's still a good going concern. So, but let's talk first about what the rent is. So you want to say, and I think you would be correct, that the rent is in exchange for what we say is your right to possess and enjoy the peaceful enjoyment of the property for a certain period of time. Typically, a commercial lease is going to be for 5, 3, or at least 2 years. At least the initial term will be. It's typically the rent is going to be scaled up to increase each year, usually by about 10%. So in the first year, you might be paying $2,000 a month. In the second year of the lease, it might bump up to $2,200 per month. And then the third year, it might go up. And these are written out in the lease that you're signing. You're committing yourself, in other words, for 3 or 5 years at these rates. It's very typical in the real estate business for the landlords to think, well, there's inflation, there's whatever, we get to bump the rent up each time. And so in the third year, they would add another 10% of the second year, and you'd have $24.20 a month, etc. So on top of that, not only is there a base rent that's going to be owed, but on top of that, many retail complexes are going to also require that you pay a percentage of the gross sales. So that means that Um, not only do you have to pay the 24.20 in the third year, but you will also have to pay a certain 1% or 2%, or I don't know what amount they're going to be, of the gross sales that you made. And that's your gross sales, not your net income. So many times that has to be factored in for these retail spaces. And but you might hopefully will have a right to renew for additional terms at similar increasing rents. Because of course, once you establish a business at a certain location, then there is a value to remaining in that location. Your customers find it convenient to stop by and do business with you or whatever, and it can be very expensive to have to move when your lease is out. But there is more to rent than just that. Many times a lease will provide that there is a late fee that's owed after 5 days or so, and that can build up. And sometimes they try to say that that is going to be considered additional. Brandy, you may want to mute while I'm talking. And even though I see a legal defense to the late fees not building up too much, it's sometimes hard to convince judges and other lawyers and landlords that what they wrote down can't be enforced the way they wrote it. But nevertheless, you want to be aware of that and not get into the position where you're having to pay a lot of late fees on top of your rent. And then there are other things that are considered additional rent. One of them are the real estate and special taxes that the landlord owes for the land that they own. So most of the time, in a residential lease, typically the landlord is going to have to take the hit on the real estate taxes himself, and it's kind of built into the monthly rent that the tenant in a residential unit is paying. But in the case of commercial real estate, many times they're going to prorate the real estate taxes across the year and divide it up by the number of tenants based on the square footage that they're renting, and make the tenants pay those taxes. And that includes special taxes, which might be for I don't know, a special district or something like that where you're located. Also, the landlord's insurance. The landlord is, of course, going to maintain insurance on the property. If they have a mortgage, they're going to have that, just like we have to have insurance when we have a mortgage for our homes. And so that's going to include the General Business Liability insurance policy that the landlord has. That's going to insure the property and the buildings against liability for accidents and injuries people might get there, against fire, theft, and storm damage to the buildings, and maybe even security coverage of some sort. And they may have some umbrella policies that, give them a balloon in case somebody gets horribly injured past the policy limits that they've acquired. And they're going to pass all of those costs off to their tenants. Whoops. So there are also going to be common area expenses that are going to be prorated among the tenants many times. So what if, what you have to consider, so what that means is, of course, divided up by the amount of square footage you are renting in a larger complex in comparison with what the other tenants are renting. And so if you can ask these questions before you sign a lease, you want to ask, what if some of the other tenants leave? Are you going to be expected to cover all of those? And it's going to include things like the costs of the landlord's utilities, the trash service, extermination if they have to You want to think about, maybe you're just a retail shop, but is there a restaurant in the complex, and are they properly handling the trash and the garbage? Are there going to be rats, and do they have to bring in an exterminator for that? If we have a snowy winter, the tenants are going to be responsible for the landlord's cost in clearing the parking lot. Now, these are all things that the landlord may incur, but is going to charge back to the tenants. If there's ice damage somewhere, that may also be charged back to the tenants. The groundskeeping, if there has to have grass mowed or some nice landscaping done, the parking lot lighting, both the utilities for that and any repairs that you may need for that. Also the sewer costs for the complex. If there's if there's a restaurant in the complex, they need to have grease traps, etc., so that the sewer system doesn't completely clog up and have to be torn up and redone. And then sometimes there's signage and, even termites. All of these costs, many landlords are going to pass on down to their tenants. And if there are any regulatory compliance, such as the Americans with Disability compliance, then they may add that. I mentioned parking lots a moment ago, but how many of you have been through a parking lot in a shopping complex that has, potholes and things in it? Many times, if the landlord has to do repairs on that, they're going to pass that on to their tenants as well. And generally speaking, the typical commercial lease will allow all of this. So another thing that you want to be aware of is many times the landlord's decision to contest taxes, the costs of that are going to be revisited on tenants. So for instance, the attorney's fees, even though you don't have a role in deciding whether or not to contest taxes, it's going to be the landlord's decision solely, and then they're going to rack up some attorney's fees for that, and they may decide to pass that on to their tenants. Now, some of these provisions may have questionable enforceability in court, but you have to get before a judge before you can get any remedy for that, even if they can't pass them on down to you under some good theory of law. And so you see that you're kind of in between a rock and a hard place here, because you're going to have to come up with some money in order to challenge that kind of a provision in court if you decide that you need to do that. So it's good to be a commercial landlord, I think, as you can see. So another term that is often in commercial leases is your renewal term. I mentioned that a few minutes ago, and that is your right to renew the lease after the first initial period of 2 or 3 or 5 years. And if you have any kind of default ever, then you can forfeit that right to renew. So you can imagine, because of all of these provisions that are, many of us don't necessarily are not necessarily conscious of in a commercial lease, you can see how easily, if you pay your rent on 1 or 2 occasions a couple of days late, for instance, even though it's accepted, that could be considered a default for the purposes of having the right to renew. So it's so easy to default is basically the message there. So another responsibility that commercial tenants have under their leases is to avoid liens against the property. So if you are renovating a space at your own cost, and if your contractor builds out poorly, for instance, or fails to pay one of the subcontractors to the contractor, then a mechanic's lien can be filed on the property. And first of all, this is going to threaten the primary lien that the landlord's bank has against the property. And that's going to put the landlord in default of its mortgage. And then that's also going to put you in default of your lease. And what it does is, many times you might want to hope to leverage a proper repair of the the contractor's work or the subcontractor's work by withholding payment. But if it causes the subcontractor or the contractor to file a mechanics lien on the property in order to get paid, then it's going to put you in default of your lease. So that kind of, again, puts you between a rock and a hard place. Also, under most commercial leases, the tenant has the duty to repair and maintain the property, at least on the inside. So, whereas in your residential lease, you just call up your landlord when the toilet breaks. Typically in your commercial places, then you're going to have the duty to do that. You're going to have the bathroom repaired at your own expense. So typically the landlord is only going to be responsible for maintaining the outside walls of the building, the foundation, and the roof. So anything on the interior. And there's going to be riders in a lot of leases, like about the plate glass windows on the front of your retail space. And the condition of the walls on the inside, and if the landlord is lax about repairing the roof, then you're going to have interior damage that may be your responsibility. Maybe you could have a theory of having the landlord reimburse you for that, but these are things that you should not rely on. You should be prepared for all of these contingencies. So your duty to repair and maintain may include your cleaning service. So you may have to have cleaning over some kind of regular basis. And again, you generally have to repair everything at your own cost. So the air conditioning unit breaks down, that may be your own cost. The heating may be your own cost. If you have certainly equipment inside, that's going to be at your own cost. So you need to factor all of these things into the economic equation that you figure when you do sign a commercial lease.
So hey, Judy,
yes,
we have a question that was posted. If this
okay,
would be time, says please discuss the difference between a full service lease and a net lease. The tenant is responsible for the increase for the operating costs from the base year of the lease in a full service lease. As a commercial realtor, I think those listening are going to think that you pay everything on top of the base rent.
Well, that's what a net lease is basically the landlord isn't paying anything. So there could be incentives that some landlords build into the initial years of a commercial lease, because the commercial vacancy rate has been pretty high in the Kansas City area, is my understanding. So I'm not familiar with the term you used. What was it again? It was but going forward, I can see that they want to make it a net lease. In other words, we might have given you these incentives in the initial year of the lease, but going forward, anything else that has to happen is going to be the responsibility of the tenant financially. Does that make sense? Hope so. Again, the tenant, if the tenant fails and the landlord pays in order to make the repair, then those costs can become additional rent under most leases terms. And the tenant will have to repair broken windows, etc. And what if there is vandalism or looting damage? We've seen some of that this year. Well, you've got to look at your own insurance policy. You definitely would want, first of all, most leases are going to require that the tenant himself or herself rather have a general business liability insurance policy in place to repair things like broken windows. And then a question I have is vandalism and looting damage going to be included under that lease? Maybe you can make an argument that they were this year, but going forward, I can see the insurance companies carving that out and making you pay an additional amount to get coverage for that kind of thing. Also, many leases require that the business stay in business. So there is a business continuation requirement. And part of that is because in shopping centers, there's kind of a domino effect. If some shops start to close, or you lose the main tenant in some of those the anchor tenant, as they call them, in some of those complexes, then it starts to really affect the value of the location itself. People don't want to come just for one shop. They want to come for several shops in the shopping center. And there can be a domino effect there. So many landlords are going to require, they'll not only require you stay in business, but they will specify the hours you have to cover. And so you want to consider, when you're signing one of these leases, do you have holidays you need to close on or want to close on? Consider the cost of having an employee there, 7 nights a week or whatever it is that the landlord's requiring. And so, are we going to have an emergency defense, in the pandemic under some of these leases? Well, perhaps, but it's probably not going to give you a defense from payment of rent. I don't know. There are so many things that changed, but you have to understand that the provisions are there to theoretically nail the tenant for many, many of these costs. And then they also will prevent you from abandoning or surrendering the property if you decide that you need to go out of business. So frankly, I have forgotten my basic real estate law a little bit here, but under one theory, if I go to my landlord and I say, I'm sorry, I have to go out of business, I am surrendering the premises to you, or and here are the keys, then you could effectively terminate your lease if the landlord accepted that. Well, most of these leases are going to forbid that. So even if they do accept possession back of the property from you, it doesn't relieve you under the terms of the lease for the amount of time that the lease is running. Then there's some more defaults that you maybe haven't thought of. Maybe your signage exceeds what the landlord's requirements were. You may have a breach of the landlord's regulations. Many times they have noise, odors, security, or they don't allow you to put handbills on the cars and things like that. Little things in the fine print that many people fail to read or understand. If you do close up and move out, then there may be a requirement that you leave what's called fixtures behind. So if you installed a countertop at the front of your store or at the back of your store, and you decide when you leave that you need to take that to your next location or whatever, if you remove that, it was affixed at one point to the realty. That's what a fixture is. It's a piece of personal property, meaning matter, stuff we can touch, is attached to the real estate, and it becomes part of the real estate under the law that way. So if you remove those fixtures under your lease, the lease, in other words, may require that you leave those fixtures behind. And so you need to consider that. And then I've even seen a provision in a lease, a regulation that says anything you do to damage the reputation of the property can be considered a default, which, that's very vague. I have no idea what that means. But that kind of language is in there. Many times they're a loop, this kind of thing is written in there so that they can hang their hat on something if they need to. Another thing you have to consider is that even if you signed your lease in the name of your business entity, you probably had to sign a personal guarantee along with it. That means that if your business can't pay, then you could potentially be held liable in your personal life for what is owed under the lease, despite the limited liability of, say, your LLC or your corporation. And then, of course, in your lease, you probably signed waivers. So most of the time, a solidly written commercial lease will require that you waive your right to have a trial before a jury if you get into a court dispute with your landlord. And then in some other kinds of contracts, I have not seen it in too many leases, because the landlords want to get into court as fast as they can in order to get rent and possession. of on a tenant that has defaulted on the payment of rent. But if there is a binding arbitration clause in your lease, then that's going to hold. They do generally. And that means you can't go to court. You have to select a private arbiter to hear the case, and then you're going to be stuck with that result and also have to pay the arbiter. Whereas if you can go to court, then the taxpayer pays the judge, so you don't have to pay the adjudicator in a court case. And then you may have more waivers, such as often the landlord requires that your insurance company, that you subrogate any claims you have against somebody. For instance, let's say somebody intentionally damages your storefront and also somehow damages a light in the parking lot or whatever, then the landlord would require that the claim you have against that individual to recover damages has to go to the landlord. And in our insurance policies, that's a requirement of our insurance policy. So for instance, in my vehicle policy, if somebody runs a red light and strikes my vehicle, my insurance company is going to pay for my damage if they have to, right? But that means that they have now the right to sue the person that struck my vehicle. That's called subrogation. They were subrogated to the claim I had against that individual in exchange for them paying the damages for my car. Well, the landlords often require that you subrogate claims you have against people that are causing damage to the property to the landlord. And my question is, where are the insurance companies coming in on that? Because they usually have the primary right to do that if they're paying for damages. And the damage, the landlord's leases are often making you assign these claims basically before there is any claim. So again, it's one of those things that there could be a legal theory to get you out of this. But again, you got to get in front of a judge somewhere, and that's expensive in order to get that kind of a ruling. And then, of course, there's a duty to notify the landlord of default before you can even terminate. And the insurance coverage for your business, you need to maintain a general business liability insurance policy. I would recommend that to anybody who's going into business. It's going to protect the property your business owns from fire, theft, and storm damage. And it's going to give liability coverage for your business activity. And if you're maintaining a space, which, that's what we're talking about, commercial leases, that means you have a space in which you're doing business. If you're maintaining a space to do business, then it's going to cover for slips and falls. If somebody comes in the door and nobody's wiped up the wet rain water, for instance, and they slip and have an injury, then your insurance company is going to cover that. And your landlord's going to require that you have that kind of coverage. So usually these business liability policies start at $1 million, and they can be pretty affordable. The premium you pay is going to be determined on what your business activity is and how much space and how many employees and that sort of thing. And you need to talk to an insurance agent about what that cost is going to be. And you need to shop that around and be a good consumer, because the insurance companies are competitive with some of their rates. So, but your commercial lease may also require that you have a low deductible for your insurance policy, which the lower your deductible, the more your insurance premium is going to be, because more of the claims are paid generally at the lower end of the damages claims. And so the more the insurance company obviously has to step in and pay, then the more your premium that they're going to charge you. And you probably have to name your landlord as an additional insured. There could also be other perils coverage that are required under your lease, like they may require some kind of terrorism coverage, or now that we've had some looting and thing damage, they might require that.
that might be an additional coverage. You know, I could see the insurance companies after 9/11, after the insurance companies, they did cover most of the 9/11 damage. But after that, I started seeing in a lot of commercial leases, you had to pay extra for a terrorism rider to get coverage from that thereafter. Maybe there's earthquake potential, probably not here, but maybe in the St. Louis area due to the New Madrid Fault that's south of St. Louis. And what is the pandemic going to do? You know, nobody ever had one for 100 years. And so now maybe there's going to, you know, maybe the insurance companies are going to cause us to have a, you know, some kind of a rider for coverage of something that otherwise wouldn't be covered because of pandemic. So we'll see. We live in interesting times, right? Is that a curse or is that a blessing? I don't know. Also, your lease is not going to allow you to assign. So if you sell your business, for instance, to somebody, then in your contract for sale, you're going to have a bunch of language in there that says that the purchaser is only going to purchase if the landlord is going to accept them as a future tenant. And you don't have the absolute right to just assign your lease rights to that person. And if you are selling your business, if you still have 2 or 3 more years on your commercial lease, then your landlord is, maybe if they do accept the new tenant, the new owner of your business, they're not going to let you off the hook for actually being liable on the lease. So you're going to want to make the purchaser of your business promise to indemnify you if they fail, if they close the business and fail to pay the rent, and you have to pay it because you gave a personal guarantee on the lease earlier. Then you want to make sure that you have a right to go after the seller, I mean the purchaser of your business, to get reimbursed for that. But you know, if they've gone out of business, then you can't get blood out of a turnip. So usually you still have your neck in the noose, even though you sell your business. So under leases, however, the landlord, of course, can assign freely, especially if they sell the property, because they're buying and selling these properties all the time, right? So, and you may be required as a tenant to accept the next landlord or a bank in case of foreclosure. And that means that if the landlord sells the property, you may not owe the rent to that landlord, but you're going to owe it to the next landlord, and you don't get automatically out of your lease. And one of the reasons for that is because, you know, part of the appeal of selling a shopping center, for instance, is that, oh, we have all of the spaces rented and they're all, you know, leases that don't terminate for another couple of years. So you've got a fully rented property that you're trying to sell to somebody. That's a selling point. So also in commercial leases, it's not unusual for there to be a provision about eminent domain. That would be if the government, a government, condemns the property for some public purpose, such as they're going to put a highway through there or something. So they're going to pay the landlord the fair market value for the real estate. And sometimes the leases will say that the landlord is entitled to all of the money from that condemnation. But as a tenant, there should be an award made to the tenant for the costs of relocation and that sort of thing. And some leases may require that that be paid to the landlord, but you should assert yourself if that's the case and make sure that you get the award you're entitled to. And then, of course, like many other contracts, which is what a lease is, it's a contract. It's going to provide that the attorney's fees and costs be paid by the tenant. They'll try to make this a one-way street. Oftentimes the commercial law attorneys, who are the ones that are suing on behalf of landlords, usually because rent has not been paid, they're earning a percentage of whatever they can recover on that. So But some may ask for an hourly fee instead. And so, here you go. Not only can you not pay the rent, but you're going to be stuck with the lawyer's fees for your landlord when you get sued for that rent. You now see why landlords are called lords. They should be called kings. There's still more provisions. There is a prohibition almost always against environmental soiling. So that means that you can't bring some toxic chemicals onto the property and have a environmental violation of spilling those chemicals, because under the environmental laws, the landlords or anybody who has ever owned the property can be held to the payment of the costs of cleaning that kind of spill up. So you're gonna get stuck with that yourself if you do have a mishandling of some kind of dangerous chemicals. So the conclusion here is that even though your landlord holds all the cards under a lease, this is a new type of environment here with pandemic, with our total economic collapse. You should be able to talk to your landlord, and the commercial who's, if you do default, try to cut a deal on how much you're going to pay in rent, either a reduced amount or deferring the rent. It would be better for you if you can get the rent forgiven instead of deferred, because deferred implies that there's going to be some kind of reckoning down the road. But who's your landlord going to rent to? I can't imagine there's many people trying to start a business now, and certainly not trying to rent stores that nobody can go into or feel comfortable going into. And so, you should have the courage to talk to your landlord and try to work something out, because everybody's in the same boat, and we just need to try to work together as much as possible and get through this. So, questions? Brandy, do we have any more questions?
Judy, yep, there is a question on
Okay.
the difference between leases for retail businesses versus office space.
Well, some of the classic things are, of course, you're not going to have to pay probably a percentage of your gross revenue and in anything but a retail space or maybe a restaurant. So an office building, hopefully an office space, you wouldn't have that provision in there, but many of the other provisions would apply, such as you have to maintain, the interior yourself. So if the plumbing breaks, you're probably going to have to fix that, unless it's a larger building. And then, again, though, all of those costs of maintaining are just going to be spread among all the tenants in the building. Okay.
Got it. Are there any other questions? You can pop those into either the chat box or the Q&A, and I can relay those to Judy. So while we're waiting to see if there are any more questions, I just wanted to remind everyone that we did record this webinar, and we will be posting it on the Kansas City Women's Business Center YouTube channel. It'll take us a couple days to edit and then get that posted. And that is also where we have been posting recordings from all of our previous Women Wednesday sessions. So you'll see basically a catalog of sessions that we've been recording since May. So we have quite a catalog built up already. And that's where this session will live as well. Judy, I'm not seeing any other questions popping up. So I think that we are good. I want to thank everyone for joining us. And Judy, I want to thank you for
welcome.
The presentation. So yeah, this one comment, thank you, Judy. This was very informative and appropriately scary. So
sorry, I should have done it on Halloween.
So thank you very much,
You're
and
welcome.
to everyone, and have a great day.
Everybody stay safe.
Yes, thank you.